Hello everyone, I'm Tao Chen. Now let's introduce part 2. The amendments to the patent examination guidelines also revised the examination rules for invention patent application involving artificial intelligence, big data, or other fields containing algorithm features or business rule and method features, while introducing for the first time provisions on the determination of patent eligibility and drafting requirements for patents related to bitstreams. First, refine the examination standards for algorithms and business method patent. 1. Overall examination principle. Technical features and algorithm business features in the claim must be considered as a whole and should not be separated. The examiner must determine whether the chain of technical means, technical problem, technical effects is established, rather than simply checking for the presence of mathematical formulas or marketing rules. 2. Baseline of legality and compliance. If data collection, label management, recommendation and decisions or other steps violate laws, social morality, or public interests, patent rights cannot be granted. For example, a mall secretly capturing facial images for precision marketing will be rejected because the collection is undisclosed and infringes the personal information rights. An autonomous vehicle emergency algorithm that selects whom to prioritize crashing into based on gender or age will be rejected as it violates the ethical principle of equal value of life. We advised the applicants that the patent application's description must include explanations of the legality and compliance of data sources, processing procedures, and usage purposes. Otherwise, the application will be rejected outright without proceeding to substantive examination of novelty or inventiveness. 3. Positive and negative examples of inventiveness. Negative example. Directly applying a fruit counting model to sheep counting without any adaptive improvements to the deep learning approach, model structure, or training method. Merely changing the regulation target lacks inventiveness. Positive example. The present application relates to a method for establishing a neural network model for scrap steel grade classification. The neural network redesigns the number and hierarchy of convolutional layers and pooling layers, significantly improving classification accuracy. Reference 1 involves performing feature extraction and model training using scrap steel image data with predetermined categories to achieve scrap steel type recognition. Although the application scenario of the present application is similar to that of reference 1, both pertaining to scrap steel identification, the technical problem addressed by its solution and the technical means employed differ from those of reference 1. Therefore, the present application possesses inventiveness. Our suggestion is, even if the application scenarios of AI are different, without scenario-specific improvements, it might be regarded as a routine transplantation. Even when the application scenarios of AI are the same or similar, it can still possess inventiveness if different features are extracted and trained, or if improvements are made to the model architecture. 4. Examples of sufficient disclosure in the description. For applications involving the structure of training of AI models, the model composition hierarchy design or connection relationships define the core architecture of the model, while the specific training steps, parameters, and other details reflects its optimization method. These aspects should be disclosed in the description. For technical means that constitute common knowledge in the field, it may be considered that the absence of such means in the description does not lead to insufficient disclosure of the description. For patent applications involving specific application of AI models or algorithms, the core typically lies in how the model or algorithm is integrated with a particular technical field or application scenario, as well as how the input and output data of the algorithm or model are defined. All such aspects must be clearly described in the description. If the technical means employed, including the intrinsic relationships between inputs and outputs, are neither explicitly disclosed in the application documents nor common knowledge, and if the solution cannot be specifically implemented based on the disclosure in the description to solve the corresponding technical problem, then the application should be deemed not to have sufficiently disclosed the solution for which patent protection is sought. The second, first-time delineation of bitstreams patent boundaries. 1. Patent eligibility examination for bitstreams. Pure bitstreams, for example, a bitstream comprising syntax element A-B, or a method for generating bitstream, characterized in that the bitstream comprises syntax element A-B, are considered rules for mental activities and are not patentable. Video encoding method for generating bitstreams and video decoding method for decoding bitstreams have already been eligible for patent protection. According to the revised guidelines, corresponding storing methods, transmitting methods, and computer-readable media implementations associated with such video encoding method for generating bitstreams are now also eligible for patent protection. Suggestion for applicants: method for storing bitstreams, methods for transmitting bitstreams, and storage media for bitstreams must be tied to a bitstream generation method to seek for patent protection. 2. Drafting requirements for bitstream-related applications. Description: the specific video encoding method must be described sufficiently in the description so that it can be implemented by a person skilled in the art. When the claims are extended to cover method for storing bitstreams, method for transmitting bitstreams, and storage media, the description must contain corresponding disclosure to support these claims. Claims, methods such as reference to the method or embedding all features may be used to incorporate encoding method feature into claims for storing method, transmitting method, or storage media. The subject matter of pure bitstreams is not protectable. The third, practical recommendations. 1. For AI company. For scenario transplantation applications, ensure that scenario-specific improvements are described in model structure, training strategies, or data pre-processing steps. Consider including a separate compliance section in the description detailing data collection authorization, anonymization measures, usage restriction, and so on. 2. For big data marketing and facial recognition company. Given the enforcement of the Personal Information Protection Law and the Data Security Law, the guidelines now explicitly list illegal collection as grounds for reject under Article 5 of the Patent Law. It is recommended to conduct data compliance audit before considering patent applications. 3. For video codec company. For video encoding decoding technologies, in addition to drafting conventional method claims, processor memory claims, storage media claims, and program product claims, company can also draft claims for bitstream storage method, bitstream transmission method, and storage media containing encoding programs and bitstreams to expand the scope of protection. However, a standalone bitstream claim is not patentable. 4. Implication for Chinese patent application. Chinese application document must simultaneously address the triad of compliance plus inventiveness plus sufficient disclosure. Direct translations of PCT English texts may no longer suffice. Consider supplementing relevant content upon entering the Chinese national phase. For patent application, involving the structure or training of AI models, and those involving specific applications of AI models or algorithms. The focus of sufficient disclosure in the description differs. In the former, the emphasis lies on the specific details of the model architecture or training process. In the latter, the emphasis is on the intrinsic relationship between the inputs and outputs. For Bitstream cases, first draft conventional claim for video encoding decoding technologies, then derive claims for storage method, storage media, and transmission method based on the encoding method. The fourth conclusion, the amendments to Chapter 9 of the Patent Examination Guidelines employ three sieves: compliance plus inventiveness plus sufficient disclosure to filter out a large number of conceptual, rule-based, and purely scenario-transposed applications in AI and big data fields. At the same time, the design of binding bitstreams to encoding method enable video encoding, decoding, communication, and storage hardware manufacturers to obtain chain-style protection. These amendments to the Patent Examination Guidelines represent another crucial step in the evolution of China's patent system toward high quality. The new rules are not barriers but sheaves. It is hoped that what is shipped out will ultimately be bubbles, leaving behind intellectual assets as precious as gold. That's all we wanted to share about the new amendments of Patent Examination Guidelines. Please do not hesitate to contact us for any questions.